During a pretrial deposition of my client, the defense attorney asked a question and I objected to it. Why is it that the defense attorney refused to rephrase her question? Would you like to know the answer? Hi, I'm Gerry Oginski, a New York medical malpractice and personal injury attorney. This was a medical malpractice case, and the defense lawyer now had an opportunity to question my client, the injured patient, in a process known as a pretrial deposition. Lawyers also call it an examination before trial. On this Zoom video call, there was a court stenographer there to record all of the questions that my client was being asked and all of the answers that she gave. The defense attorney was on the call, I was on the call. Now, this pretrial deposition will take many, many hours and in fact could take the entire day, which means that you, the injured patient, are going to be asked hundreds and hundreds of questions throughout the entire day. Questions about your background, about your work history, and then about the details of exactly what happened, as well as the details of what your problems are today and those things you cannot or are unable to do or do with difficulty. Now, during the course of questioning, this defense attorney asked a question that I felt was not phrased properly. There was an issue with the way that the question was phrased. And I said, "Objection! Please rephrase your question." The defense attorney said, "No, I'm not going to rephrase my question. I want an answer to my question." Now, what does that tell me? It tells me a number of things. Number one, it tells me that this attorney is usually inexperienced. Number two, it tells me that this attorney does not understand how they can still get the same information by asking the question a little bit differently, by rephrasing the question. Three, it tells me that this attorney is insecure and does not recognize and does not understand what it means to go ahead and rephrase a question. They think in their mind that they have to ask a question a particular way. And if they don't, something bad, something terrible is going to happen. And their rights, their clients' rights, are going to be totally destroyed if they don't get an answer to the question the way they phrased it. And I also happen to think it happens to be a control issue. Some attorneys feel that they are in control asking the questions, and if they don't get a precise answer to their particular question, that they have lost control and now they are going to be reprimanded or suffer significant consequences on behalf of their client, and now they're going to be deprived of all sorts of rights as their case proceeds forward. Well, I will share something with you. In my opinion, nothing could be further from the truth. I find that the best attorneys are the ones who, when they are faced with an objection to the form of the question, simply say, "Okay, no problem, I'll ask it a different way." And if I object again, those attorneys will turn around and say, "Fine, no problem, I'll ask the question a different way." And I find that the best attorneys are ones who can go ahead and ask the question 10 different ways, 20 different ways, 30 different ways. Why? Because that's what a good attorney does. And they have these pre-formatted questions that they think that they have to ask in that exact fashion. And if they don't or are unable to ask the question in that exact manner, they think something devastating will happen to them or to their client. But again, nothing could be further from the truth. Instead, if there's a problem with the phrasing and the attorney doesn't recognize what the problem is, simply say, "Fine, no problem." Or the better practice even is to say, "Let's go off the record a second." And now have a brief conversation with me and said, "Listen, I'm sorry, I'm doing my best. I'm trying to understand why you are preventing your client from answering this question. And now this question, I think, is appropriately asked, appropriately phrased. Could you please share with me, could you explain to me why you believe that the question is not properly phrased?" If you approach that in that fashion, many times, the attorney will simply say, "Okay, why don't you try asking it this way? You're still going to get the same information. Try it this way. The problem I have is these two words mean and have a different significance than what I think you perceive it to be." And the better practice then is to take that information, go back on the record, and continue the deposition by asking the question a different way. This comes up over and over and over again, I have found, with younger attorneys. The smart attorney is the one who's a bit creative. And if you cannot get an answer to that exact question, put it aside, move on, ask questions for the next hour, and then come back and ask it a different way. And I promise you that you likely will not have a problem at that point. But it's fascinating because there creates a lot of tension when the defense attorney asks a question I say, objection. Could you please rephrase the question? It's not phrased appropriately. And instead of the attorney simply saying, sure, no problem, they say, nope, this is my question, it's my deposition, I want this question answered the way I want to ask it. You can ask whatever questions you want, provided they're appropriate. And now, if I feel that they are not appropriate or are going to lead to further problems or confusion down the road, I have an obligation to speak up and to voice my objection. Now, even though I raise an objection, there are many instances where my client will still have to go ahead and answer the question. Now, you may be saying, wait a second, all of this nonsense for the fact that, yes, your client is going to have to answer the question anyway? This is known as the discovery phase of the lawsuit. And in discovery, there's a lot of leeway that's given. It doesn't mean that this information can be used at the time of trial. Here's an example of a compound question. Mr. Jones, on January 10th, was it raining outside and did you bring your car to a full stop before the accident? Objection, that's a compound question. And now the attorney may start arguing with me about what's wrong with my question. Well, a compound question, for example, in this hypothetical, means that there are two questions contained within one. And if my client were to answer yes, how do we know that that yes refers to the weather and refers to whether or not he stopped this car in time? The problem is we don't. So the better practice is to break that question into two questions. Mr. Jones, on January 10th, was it raining outside? Yes or no. On the day of the accident, were you able to bring your car to a complete stop before the accident occurred? Yes or no. So now we have single question and a single answer. That is a much better question or series of questions to ask. This deposition is recorded by a court stenographer, and that information will then be transcribed into a booklet known as a transcript. And later on at trial, in preparation for trial or at trial, we can read that transcript or portions of it to the jury. And now that information can be critical to one side or the other. Why? Because it could help one side or the other. But the problem will arise if the question was not clear to begin with, and now the witness gives one answer and it's ambiguous. It's not clear as to what they are answering the question to. Are they answering it about the weather? Are they answering it about the second part of the question? So in that instance, I simply would say, Ms. Jones, could you please rephrase your question? If she digs her heels in and says, I am not going to rephrase my question, this is appropriate, I'm now going to go ahead and continue asking this question over and over again. Well, what happens if she does not go ahead and change up her question? Well, a couple of things could happen. If she does not continue on with other questions, I could say, listen, if you have nothing else to ask and you refuse to continue further, then we're going to bust this deposition, meaning we're going to end it now because clearly you have no interest in asking my client anything else. If, however, you think this is an important point, we'll mark it for ruling and then you can make a formal written request to the judge at a later time to see whether or not this is so important that now my client has to be brought back and answer your specific question. Another alternative would be that the defense attorney gets so upset and frustrated that she attempts to call the court to get an immediate ruling. If that were to happen, a number of options could occur. She could call the court if I were willing to participate in that conversation, and if the judge was available to listen to this minor dispute that was going on during the deposition, then the judge could issue an immediate verbal ruling that we would have to abide by. However, there is no requirement that I go ahead and participate in a call to the court. And in that instance, if I do not participate, the defense attorney cannot have a one-sided conversation with the judge about the issue that is going on right now during the deposition. Why is that? It's because the judge cannot have what's known as an ex parte conversation with just one side. Both parties, both attorneys for each side has to be present on the call in order for the judge to get on and to listen to what's going on. So why do I share this quick information with you? I share it with you just to open your eyes and to help you understand how these types of cases work in the state of New York. You know, I realize you're likely watching this video because you have questions or concerns about your own matter. Well, if your matter did happen in New York and you have not yet started a lawsuit, but are thinking of doing so and still have questions that need to be answered, what I invite you to do is pick up the phone and call me. You know, I answer questions like yours every single day and I'd love to chat with you. You can reach me at 516-487-8207 or by email at Gerry, Gerry, at oginski-law.com. That's it for today's video. I'm Gerry Oginski. Have a wonderful day.